Hello, everyone. My name is Alex Rushing, and I'm an attorney in Husch Blackwell's education group. Before we begin, I have the honor of explaining a few housekeeping items. For those of you who attend our webinars regularly, this is old hat, and feel free to mute me for the next 75 seconds. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast or some words of encouragement, please submit them via the question box. We will try to answer all questions during the webinar today, but if a fuller answer is needed and we do have a really complete program today, we'll get back to you via email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing within your institutions or organizations. Toward the end of the program, be sure to complete our short survey. We'll use your feedback to plan future programs that are applicable to your needs. And actually, this program was inspired by one of those submissions, so please keep that feedback coming. That's all for the housekeeping items. Let's get started with our program. Joining me today are my wonderful colleagues, Jordan Alt and Mackenzie Conway. Jordan works with churches, synagogues, mosques, denominational entities, faith-based schools and healthcare providers, neighborhood and community groups, and other nonprofit organizations of all sizes. He often provides daily guidance on a range of legal and strategic questions, while also overseeing a wider team of attorneys that provide a one-stop shop for a variety of legal needs, including real estate, employment, tax, corporate, and other matters. Prior to joining the firm, Mackenzie taught students of diverse abilities and backgrounds at a public charter school in Kansas City. Mackenzie guides clients on proactive compliance, training, and policies that meet and exceed a wide range of changing regulations and place both public and private schools on optimal standing to face unexpected challenges. As I said, my name is Alex Rushing, and I'm a senior associate in our education group. I counsel schools on investigations, litigation, and compliance matters arising from a wide range of civil rights issues in response to internal and external complaints following alleged student or employee misconduct involving harassment and discrimination, including related to Title IX and sexual harassment and assault. So with that, let's get started with our agenda. So as you'll see on your screen, we're first going to dive into the background of Title IX, discussing some of the general principles that apply. Then I'll turn it over to Mackenzie to talk about the case law updates and the conflicting Title IX case law that we're seeing. Then I'll turn it over to Jordan, who will talk about some reading the tea leaves and some other statutory provisions that allow us to read some of the tea leaves. And then I will conclude with the Title IX 101 portion of our presentation. We don't know if we'll get to the complete part of the Title IX 101, but be sure to look at that PDF that I mentioned. We have a great deal of material at the very end of our presentation, but we want to hit the big highlights at the end. So if we don't get to everything, take a look at the PDF and it'll have that information for you. So let's get started first with a poll question. We want to figure out who is in our audience. I was a third grade public school teacher before I became an attorney and went to the dark side. And so I always love to figure out who's in my audience. So let's start it with a poll question. How familiar are you with Title IX? I've never heard of Title IX. I have heard of Title IX and it's being mentioned, but I don't know what it entails. I am somewhat familiar with Title IX, or you are a Title IX expert. You are a Title IX guru, so to speak. We'll wait a few seconds for those results to come in. I can see them coming in on my slide, but we'll give people a few seconds. Okay, great. Let's see who's in our audience. So the majority of you are somewhat familiar with Title IX, about 62.4%. Very few of you have never heard of it or have only heard of it mentioned, but you're not sure. And I've got almost 30% of you who are Title IX experts. I'm really excited about all these categories. Thanks, everyone, for joining us. We've got one more poll question. What type of entity are you involved with? We have all sorts of different organizations within our footprint, within our reach today, and we're seeing all of those attendees, but we'd love to hear from all of you and for you all to share. What type of entity are you involved with? I'm a school not receiving federal funding. I work at a school receiving federal funding. I am with another nonprofit and we don't get any federal funding. I am with a nonprofit that does get federal funding, or you're none of the above. I guess I would select none of the above since I work for a law firm and we don't receive federal funding. What would you select? We'll wait a few seconds. One last second to submit your results. Okay. We have about 10% of you who are with a school that doesn't receive any federal funding, so maybe a religious K-12 or an independent K-12. 58%, almost 59% of you are with a school receiving federal funding. I see a lot of higher education institutions on here, and so you all probably fit within the vast majority of that. We've got about 7.8% of you who are another nonprofit that don't receive any federal funding. So you have maybe a 501c3 status, but you don't otherwise get any funding from the Department of Education or any other organization. An identical number of you are with nonprofits that do receive some sort of federal funding. And then we've got, looks like maybe 15% of the folks on the line who maybe work for a law firm like Husch and are attending for their CLE hours or to learn a little bit more about Title IX. Excited to have all of you. Thanks so much. So let's start with what Title IX is. Here's the text from the regulation itself, and you'll see that we've highlighted on this slide in italics and bold that it really covers the issues of on the basis of sex discrimination, and for entities that receive federal financial assistance. Now, my section of the presentation, I'm going to be previewing a lot of what Mackenzie talks about and talks about how there's some inconsistencies. So this is actually the text from the regulations itself. It actually has the language receiving federal financial assistance, which can make some of the case law that Mackenzie talks about a little bit confusing as to what that means. And who does Title IX apply to? These are entities who receive federal financial assistance, including those of you who are colleges and universities that participate in Title IV funding. That's sort of an obvious example. It does not apply to individuals individually. It obviously applies to institutions, but you are required to adopt policies that apply to individuals, of course, but it doesn't apply to an individual. It applies to an organization. But we'll dive into a little bit of detail as to some of the court interpretations as it relates to nonprofit status, as it relates to exemptions, as it relates to receiving PPP funding or other sort of government assistance for those of you who may be in that category of institutions. So what sex discrimination does Title IX specifically apply to? So the regulations that were promulgated during the Trump administration, I'll dive into those during the Title IX 101 section of the presentation, but they specifically related to sex discrimination within Title IX that applied to sexual harassment. We know that Title IX generally, though, applies to sex discrimination in an education program or activity of, again, a federal funding recipient. That's sort of that trigger piece. And an education program or activity includes all operations of an educational institution. It's not just sort of the in the classroom pieces, and those of you who are at higher education institutions or who have to comply with Title IX because you're a public school district, for example, you know that this doesn't just apply to the in-classroom behavior. You know it applies to athletics, clubs, dances, graduation, academic records, all things like that. So it's much more than just sort of what we think of as like the day-to-day educational issues. It's the entire operation. But it doesn't apply to private conduct that occurs in a private location that doesn't have any connection to the education program or activity. That seems like it should be clearer. And unfortunately, in application, it can be really challenging what that actually means. And so we'll dive into that at the end of the presentation. In this slide, we talk a little bit about what historically Title IX has not applied to. And some of you may fit into these categories based on our prior poll question. This is actually where we derive that poll question. So private schools not receiving federal financial assistance from the U.S. Department of Education. So I see a couple independent schools that are on the line. I see a couple religious K-12 schools. You all that don't get, any Title IV funding, any Title I funds, this would probably be where you fit in that category. Religious schools and organizations not receiving federal financial assistance. I see some churches that are on the line that are not affiliated with a higher education institution. You may fit into that category. To nonprofit organizations not receiving federal financial assistance, I see some other folks here that are from healthcare organizations that are other nonprofits, but that don't have any affiliation with the Department of Education, and then obviously private businesses. I will flag that this slide, Mackenzie is going to dispel some of the myths on this slide in her coming presentation. So with that, without further ado, I will turn it over to my amazing colleague in Kansas City, Mackenzie Conway, to talk about some of the changes that may be coming down the pike. Mackenzie?
Thank you, Alex. So before we get into the changes, we did have one question come in that I just wanted to clarify, and so that was, who does Title IX apply to? So Title IX protects everyone who interacts with a school from discrimination. So that would include students, as we'll see in these two cases. That also includes parents and guardians, employees, and prospective students or applicants. So just wanted to touch on that quick before getting into these changes. All right, our first case that I know everyone has been waiting anxiously to hear about is the Buettner-Hartsoe v. Baltimore Lutheran High School Association for the school that's named Concordia Preparatory School, or CPS. So in this case, there were 5 former female CPS students that brought 5 individual cases making similar allegations of sexual assault and verbal sexual harassment by male students at the school. And these allegations dated back to 2016. They allege that school officials failed to adequately address their numerous complaints or take any meaningful action, thereby cultivating a hypersexualized culture at the school. CPS sought to dismiss the lawsuit on the grounds that it was not subject to Title IX. So as Alex just mentioned, typically we think that private schools, and in particular private religious schools, are not subject to Title IX. And that's exactly what CPS argued. They were not subject to Title IX because they did not receive federal funding during the time frame of the alleged sexual misconduct. So what happened with the Buettner-Hartsoe case? Again, this case was in the District of Maryland, and the District of Maryland denied CPS's motion to dismiss, holding that CPS was indeed subject to Title IX by virtue of its 501c3 tax-exempt status, even though it did not otherwise receive direct financial aid. So in holding this, the court found that the school's tax-exempt status was a form of federal financial assistance. And in particular, the court said, enforcing the mandates of Title IX in schools with 501c3 status aligns with and protects the principal objectives of Title IX, to avoid the use of federal resources to support discriminatory practices and to provide individual citizens effective protection against those practices. And again, this was in the District of Maryland. So while this case does not extend to other circuits or other states throughout the country, interestingly enough, also in July 2022, in California, across the country, there was a similar holding. In the second case, which was E.H., the Valley Christian Academy, there was a female student who played wide receiver for a public high school football team during a California Interscholastic Federation scrimmage against Valley Christian. At the end of the game, the student, E.H., removed her helmet, which revealed that she was female. According to the complaint, Valley Christian later sent a letter to EH's school stating that EH could not play in future football games because she is female, citing religious objections. EH sued Valley Christian for violating state and federal laws, including Title IX. So EH alleged that Valley Christian is subject to Title IX because, similar to the Buettner-Hartsoe case, Valley Christian is tax exempt and a 501c3 organization, and because Valley Christian received federal financial assistance in the form of a PPP loan. Valley Christian filed a motion to dismiss in which it argued that receiving a PPP loan does not constitute federal financial assistance. Valley Christian argued that PPP loans were guarantees issued by the Small Business Administration, not federal financial assistance. Even though the FAQ from the Small Business Association says that a loan through the Small Business Association is federal financial assistance. The school also asserted that simply being a tax-exempt organization does not mean it receives federal financial assistance. So a similar argument to the Buettner-Hartsoe case, with an addition of the issue of PPP loans, because Valley Christian received PPP loans as a result of the COVID-19 pandemic. What happened in this case? The court denied the motion to dismiss and held that EH could proceed with her lawsuit. The court found that, absent any controlling precedent or strong legislative history to the contrary, the plain purpose of Title IX is controlling. The court opined that the purpose of Title IX is to eliminate discrimination in programs or activities benefited by federal financial assistance. The court found that distinctions as to the method of distribution of federal funds was essentially irrelevant. Accordingly, the court held that Valley Christian's tax-exempt status confers a federal financial benefit that obligates the school to comply with Title IX. Based on precedent in similar anti-discrimination suits, although not Title IX, the court found that EH sufficiently alleged Valley Christian's receipt of federal financial assistance in the form of PPP loans was valid. So what has happened with these cases since? Obviously, they're not done yet. With the Buettner-Hartsoe case in the District of Maryland, CPS, which is the Baltimore Lutheran High School Association, appealed the decision in early September 2022. The plaintiff has replied, and CPS has also replied, so there has not been any action on the case since around September 29th, 2022. So we expect that this is obviously something that will go up to the circuit court out there. For the Valley Christian case, this case is currently in the discovery phase with a trial set for October 2023. And so this is a case we will keep an eye on to see if it gets to trial in October or what happens in the meantime. So with all of that, those are the two big cases that we've seen that we think might have an impact on the application of Title IX to schools and nonprofit organizations that typically haven't had to comply with Title IX. All right, let's see if I put you all to sleep or if you've been paying attention as we've gone through this. We've got a poll question. What did the court decide in these cases? I have a few minutes for you all to answer the poll question. So private schools can be subject to Title IX compliance. A private school receives federal funding due to the school's status as a 501c3 tax-exempt organization, or PPP loans can be considered federal financial assistance, and then all of the above. Seeing some responses starting to come in. Do a couple more seconds. All right. Oh my gosh, 94.4% of you were paying attention. Thank you for sticking with me through all of that. That is all of the above. The court said, yes, private schools can be subject to Title IX. Here's why. This tax-exempt status and receiving PPP loans. So you might be wondering, why do these cases matter? As we've touched on a couple of times, independent schools are not traditionally required to comply with Title IX unless they receive federal financial assistance. Title IX defines federal financial assistance to include federal grants, loans, other contracts and agreements or arrangements that has as one of its purposes providing assistance to any education program or activity. There's potential for the interpretation of this definition of federal financial assistance to be expanded in light of recent case decisions. And by that, we mean it could be expanded, as Jordan is going to talk about shortly, to other federal statutes, as well as expanded to other types of organizations. But before we get into the expansion, these cases aren't the only cases where we've seen kind of conflicting guidance on does Title IX apply or not. A few courts in the past, slightly long ago, have used an entity's tax-exempt status as evidence that an otherwise private business receives federal financial assistance under Title IX and a parallel statute, Title VI, which Title VI prohibits discrimination on the basis of race, color, or national origin under federally assisted programs. So in the McGlotton case in the District of Columbia, the court found that a tax exemption constituted federal financial assistance in the context of Title VI litigation. And then in the Fulani case, the court concluded that the defendant received federal financial assistance within the meaning of Title VI and Title IX because it received grants, which we know, and because it was tax exempt. However, there are other courts that have said what we all take to be true, that tax-exempt status is insufficient. Courts have long held that a tax-exempt status without more is insufficient to subject an organization to the anti-discrimination requirements of Title IX. Courts have held, however, that such status does not constitute federal financial assistance within the meaning of Title IX. For example, in the Russo case in the Western District of Pennsylvania, the court expressed doubt that obtaining tax-exempt status would transform a private religious school into a recipient of federal financial assistance for purposes of Title IX. And another court in the Martin versus Delaware Law School case said assistance connotates the transfer of government funds by way of subsidy, not merely exemption from taxation. So we see that courts are kind of split on this issue, but it has not been addressed by the circuit courts and the higher up. With respect to PPP loans, other courts have considered whether a PPP loan is federal financial assistance specifically for Title VI and the Americans with Disabilities Act. So, as I mentioned, Title VI excludes from coverage a federal contract of insurance or a guarantee, for example. And so it is a similar statute to Title IX in that it prohibits discrimination against individuals under any program or activity receiving federal financial assistance. In the Fernandez case in 2021 in the Southern District of Florida, the Florida District Court considered whether the defendant's receipt of a PPP loan constituted federal financial assistance, finding that it did under Section 504 of the Rehabilitation Act of 1973. So, with all of this information from where we are now with our recent cases from Maryland and California, and kind of hearing the background of where we've been, I'm going to pass it over to Jordan to try to read the tea leaves and figure out where are we going and what do we think is going to happen next.
Thank you so much, Mackenzie. I will start out by acknowledging my imposter syndrome, which is telling me that I'm uniquely unqualified to be here today because I do not practice much in the education arena. However, I'm here as co-chair of our firm's nonprofit organizations and religious institutions team. So much of my practice is working with mission-driven, tax-exempt organizations, many, perhaps most of which are religious or religiously affiliated clients. I've spent a lot of time reviewing higher court decisions involving issues of religious organizations, and I think they may have some impact here. So I'm going to do my best to read the tea leaves. But I'm going to start by letting some organizations that may be impacted by this change speak for themselves. In the Buettner-Harso case, there was an amicus brief, and we just had a discussion about whether it's amicus or amicus. It's 50-50 there. But essentially, for those of you who don't do a lot of appellate work, an amicus brief is a friend of the court brief. It allows entities that may be impacted by litigation to weigh in even though they are not parties. And there was a brief filed by 7 organizations in that case: the National Business Officers Association, the National Association of Independent Schools, and 5 regional associations of independent schools. In addition to those 7, there were 54 signatories. Don't worry, I won't go through all of them. However, I'll highlight a few. The Council for American Private Education, the Association of Boarding Schools, representatives of Montessori and Waldorf schools, and I think this is critical. A large number of those 54 signatories are related to religious organizations or religious education organizations. The largest, and probably the one with the most clout, is the U.S. Conference of Catholic Bishops, but there are also representatives on behalf of schools that are associated with Christian, Episcopal, Lutheran, Islamic, Orthodox Jewish, and many other faiths. Together, according to this brief, these parties represent over 30,000 private schools and over 4.6 million students. So they're speaking on behalf of a large number of schools and students. All of these signatories and organizations are nonprofit. They all have a 501c3 tax exemption. They are all, as 501c3 organizations should be, guided by specific missions and overseen by independent boards. And, as you might expect, most are primarily financed through tuition and charitable contributions. And they acknowledge that their 501c3 tax exemption essentially gives two big benefits. First, for the organizations themselves, which have some tax relief, and second, for the supporters of those organizations who may write checks to support them, and those checks might be or should be tax deductible. So what did these organizations say? The arguments probably aren't surprising to you. Essentially, they argued that the extension of Title IX to independent schools would impose massive prescriptive compliance regimes that would overwhelm those entities both financially and administratively. They spoke a lot about the balance between, on one side, investment in quality education and the safety and health of students and staff, and on the other, keeping tuition affordable and keeping salaries competitive to retain teachers. They argued that expanding Title IX would upset that balance. They argue that they already do this. They already protect students and staff through rigorous and effective safeguards tailored to their size and their mission. And the last 2 points here, they essentially argue, wait a second. We have declined federal funds and federal financial assistance in the past based on the absence of any kind of definition of federal financial assistance that would include tax exemptions like 501c3 status, and the understanding that the government has never brought an enforcement action against a nonprofit that does not receive federal funds for failing to have a Title IX program. So what are the consequences? Those are the problems. They're obviously, I'm sure, very obvious problems. The NAIS says that 12% of its members have an enrollment of fewer than 100 students, and that expanding Title IX would essentially force those schools to hire staff or take teachers or administrative staff that are already spread too thin and spread them even thinner. Essentially saying, without really saying, that they expect a number of their schools to close the door if this happens. They argue that the interpretation of federal financial assistance utilized by the court, that is to include 501c3 status and the resulting benefits, could trigger a host of restrictions applicable to recipients of federal grants generally. And the third point is, in my opinion, the most important. They focused on independent school policies that are, to use their words, legally compliant, mission consistent, and tied to deeply held beliefs in the community. So I'm going to do something that's probably very foolish here in a second and try to read the tea leaves and predict what a higher court might do if there is a split here or with this split. But before that, I'm going to kick this over to Alex, who knows how to do these poll questions, and see if she can handle this next poll question.
Thank you, Jordan. Appreciate it. So Mackenzie did a poll question where she was checking your understanding to see if folks were awake after she presented on the topic. Now we're going to take an opportunity to see if anyone already knows the answer to this question before we've maybe told you what the answer is. So for my 30% earlier who said they were Title IX experts or gurus, I hope there's at least 30% that get this right, because this should totally fall within your wheelhouse. So we're putting up another poll question. Courts have historically interpreted Title IX consistent with which other federal law? Title I, Title VII, the Americans with Disabilities Act, or I don't know and I don't even want to guess. We'll wait a few seconds for everyone to answer. I see I have almost 40% of folks have responded, hoping to keeping to see that number rising. Okay, great. Let's see what the results are. We have about 4% of folks that say Title I. We have 71.7% of folks who say Title VII. 10% say the Americans with Disabilities Act, and 14% didn't want to answer, didn't know, and just were not sure about even the first three options that we gave. The correct answer that Jordan will dive into a little bit more deeply, is Title VII. Historically, federal courts have interpreted Title IX similarly to Title VII. You may know that from the Bostic decision that came out in 2020. Their statutory prohibitions against sex discrimination are similar, such that Title VII case law is frequently used as a guide to inform Title IX. So there's our poll question. I'll turn it back over to you, Jordan, to dive a little bit deeper into those tea leaves.
Thank you so much, Alex, and well done, everyone. Yeah, as 71% of you said, Title VII is often used as a guide to inform Title IX jurisprudence. Title VII prohibits discrimination in employment, both private and public, based on race, color, religion, national origin, and sex. There are exceptions to that. And there's one that I want to speak about because as I look at this, it's something that I think may impact a number of our individuals on the line here that are in religiously affiliated private schools and maybe other non-religiously affiliated private schools. One of the exceptions is what's called the ministerial exception, which immunizes religious institutions from discrimination claims brought by ministers. This came from a couple Supreme Court cases, the Hosanna Tabor case, the Our Lady of Guadalupe case, and over the last few years and Supreme Court terms, the ministerial exception has been expanded significantly. First, expanded in who qualifies as a minister. It's not just the clergy in the pulpit or religious leaders. For this group, it is often teachers or even non-teacher staff at religious affiliated schools that have some sort of religious duties. What could those be? It could be teaching theology or ecclesiastical issues. It could be offering or leading prayers. It could be taking students to chapel. The definition of who qualifies as a minister has expanded quite a bit, but also the type of behavior that falls under the ministerial exception has expanded. Now, I understand there are a lot of people who may be thinking about this and said, well, what could that possibly have to do with the application of Title IX? The discrimination that Title IX is intended to fight against certainly can't be related to any sort of religious or theological beliefs. And a couple of years ago, I probably would have agreed with you. Most of the time, the ministerial exception applies to we've seen some clients that are historically black churches that want to hire clergy based on a certain race, color, religion, national origin, sex. Some religious institutions that have beliefs about who can hold certain roles, often roles that are relegated to men in their faith tradition. However, as I mentioned, I've seen that expand. In the Seventh Circuit recently, in a case called Demkovich, there was a case brought by a minister claiming not only discrimination but hostile work environment. This minister had a disability and claimed that he was mocked publicly by the lead clergy, which created a hostile work environment. And the Seventh Circuit looked at that, and although there were some arguments that obviously making fun of someone's disability could not be protected or could not be tied to a deeply held religious belief, the Seventh Circuit found that the hostile work environment claims fell within this exception. They basically said, we're not going to try to determine what a deeply held religious belief is. We're going to allow religious organizations, religious employers, the freedom to make those decisions on their own, whether we like it or not. Now, why do I think that's important here? If you've watched the Supreme Court over the last few years, and I do think there's a chance that this issue could make it to a higher court, perhaps even the Supreme Court, I think you have 5, arguably 6 justices that would fall all over themselves to be the justice writing an opinion that expands the ideas of religious freedoms. There's always been this kind of push and pull about the prohibition of discrimination on one side versus the expansion of religious freedoms on the other. And over the last few terms of the Supreme Court, the adherents to expanding religious freedoms have often been in the majority. I think there's a good chance that might happen here, that there is an argument that Title IX should not apply to religious private schools because it would impinge on their religious freedoms. Now, I know not all independent schools are religious or affiliated with religious entities. However, I think there's at least a chance that they might get swept up with religious schools. Now, as I said at the beginning, this is a very foolish thing to do, to try to read the tea leaves and guess what a higher court might do in the next few years. However, based on the case law and the opinions that I've seen, I suspect that that may be a big argument that we see before higher courts, including the Supreme Court, in the next few years. Now, there was some mention of the expansion if Title IX applies and if having 501c3 tax benefits essentially means that you are receiving federal financial assistance. One area would be Title VI. Title VI typically only applies if an organization receives federal financial assistance. So the implications of these Title IX decisions may also impact Title VI. And in some ways, it may also apply to some disability statutes. The Americans with Disabilities Act and others typically apply to all employers, all organizations, public or private. But there may be some portions of those statutes where the expansion of Title IX to independent schools might change the application of these statutes as well to some of those schools. Far be it from me to predict how that might happen in the future, but it's something to keep your eyes open for. And with that, I think that's as much tea leaf reading as I can do. So I will go ahead and pass it back on to Alex, I believe.
Yes, thank you, Jordan. Appreciate it. So now we get to the portion of the presentation where we're going to do a little bit of Title IX 101. And we saved this for the end for those of you who are really familiar with Title IX. This is going to be a great refresher. It may be something that refreshes your memory on things that you haven't seen come up as often at your institution or your organization. And for those of you who really don't know much about Title IX, like when we did our original poll questions where you've heard of it, you really don't know what it entails, but there's a lot of media coverage about it. You see a lot on social media or elsewhere, and you just wanted to learn a little bit more, or why should we be afraid of Title IX applying to our organization? That was one of the questions that sort of came up within our question and answer section in our inbox here. And I think that's a really fair question. Part of it relates to the fact of how robust the regulations that were promulgated during the Trump administration. They are extremely robust and really changed the landscape, at least from my practice, the 5-6 years before the regulations and then since then, of what really is required for an institution or an organization that Title IX is being triggered for. What do they have to do in order to comply with this portion of Title IX? So hopefully we'll answer some of those questions, but feel free, our question and answer box is still open. We would love to answer any questions during this portion of the presentation or afterwards as it relates to this really, really important topic. So in terms of a regulatory update, where we stand in terms of a procedural history with the regulations, on June 23rd of this past year, on the 50th anniversary of Title IX, the U.S. Department of Education released its notice of Title IX proposed rulemaking that the Biden administration intends to submit its version of the Title IX regulations. It still requires that notice and comment period, responses to comments, and then finalizing what those regulations actually look like. The 2020 regulations that the Trump administration, with former Secretary DeVos, when they submitted those, they received hundreds of thousands of comments that they had to respond to every single one of them individually. And I remember during that time so distinctly the 1,700 pages of documents that had all the comments and all of the answers to the comments, and making my husband print those so I could highlight them. I'm sort of a little old school about that. So this really is a robust process that the Biden administration is going through to try and change some of this. None of those proposed regulations are in place right now. We don't have any sort of tea leaf predictions here about that. It may be in the spring. It may be sort of at the May time period like we saw it during the Trump administration, where the implementation is for the next academic year, but we don't have any of that information right now, unfortunately. I wish there was a little bit of clarity there that we could share with all of you. So as it currently sits, compliance with the August 2020 regulations is still mandatory. You're still good with complying with what you, for those of you who have been complying with the Title IX regulations, you're still in great shape on that. But let's answer some questions about what actually do these regulations apply to. They're very narrow in their application, and specifically Title IX covers any type of sex discrimination, right? But the Title IX regulations that we're going to be talking about specifically relate to sexual harassment and conduct that is specifically on the basis of sex that falls into one of these 6 categories. And I'll dive into a little bit more detail of what exactly those categories are. So the first category is this quid pro quo harassment, and this relates only to an employee of an institution conditioning a provision, benefit, aid, something like that, on another individual, student, a fellow employee, an intern's participation in unwelcome sexual conduct. A question that I get very frequently is whether, if it's a student at an institution conditioning the provision of some benefit or aid, if that can be quid pro quo, if the student is not an employee, right? And in this circumstance, under the Title IX regulations, it has to be an employee of the institution. Now, we know that students can also be employees, right? So that if it's a student employee, obviously it would count. But if it's just a fellow student, quid pro quo harassment wouldn't arise in that particular context. And it can be employee versus student, employee versus employee. The person who is subjected to the conduct doesn't have to be an employee. It's not just an employment circumstance, just to answer any of those questions preemptively. The next category of conduct that's prohibited under the 2020 regulations relates to hostile environments. And Jordan talked a little bit about this in terms of the ministerial exception, the Seventh Circuit. And so it's interesting to sort of see some of that and its parallel to Title IX. Here, the Title IX regulations that for those of you who accept Title IV funding or are public school districts, this is unwelcome conduct that's determined by a reasonable person, not any person, but a reasonable one, to be so severe, pervasive, or persistent and objectively offensive. Now, we know in Title VI, the reason why we underline that and is because in Title VI, it's an or, actually. And so this was a little bit of a distinction where it's not just that it is severe. It has to be severe, pervasive, and objectively offensive, or severe, persistent, and objectively offensive. So that and really made a difference, and it must deny a person equal access to the university's education programs or activities. That program or activities is what that trigger is. And then sexual assault is the final category that I wanted to talk about among the 6 that we flagged in the beginning. This is what gets sort of the most, I think, attention. Some of these other categories that we talked about maybe don't for whatever reason. I don't know if it's sort of the headlines or whatnot, but sexual assault is covered within this, but it's not necessarily the most common piece of what is actually triggered within our regulations. It certainly is triggered, but it's not, I would say, the most common, at least in my own practice. That hostile environment, non-sexual assault sort of conduct is what, at least in my experience, is what is the most common. So in the regulations, they describe sexual assault as falling into these classes of conduct. They define it very specifically in this way. And so for those of you who have worked with us on implementing your policies and practices and procedures related to this, it follows and tracks this exact definition. Consent is another piece that I want to talk about because it really relates so much to what we're covering within this portion of the presentation as it relates to Title IX. And I think this is one of those areas where maybe folks who practice in this space very regularly know a lot about this, but for those of you who responded that you don't know much about Title IX, I think consent is the one area that I hope that you take away from, that even if the Title IX regulations don't apply to your organization or your institution, figuring out what is consensual and non-consensual conduct and how to discipline or investigate and adjudicate issues where there's non-consensual conduct, that's just a great practice overall. Whether Title IX applies to you or not, that's just sort of my practical advice. And so the piece that I want to focus on related to this slide, because all of it is important, but I'm very cognizant of time, is the second portion. A person who is incapacitated cannot consent. In this circumstance, we think a lot of times of individuals who are incapacitated due to alcohol or other drugs, whether that's prescription or illicit, all those sorts of things. It doesn't necessarily mean that the person is incapacitated at their own will, right? They could have had alcohol, other drugs, or anything like that given to them without their consent. So it could be sort of two pieces related to the consent, or it could be that they intended to incapacitate themselves. So it falls under multiple different categories within that piece. And I think that's one of the portions, at least related to the consent part, that I think is a great takeaway for all of you. Here's what the resolution process looks like for those of you who are organizations that don't have anything to do with Title IX normally and are maybe starting to slowly get a little bit scared if Title IX does end up coming your way and has to apply to your school or your nonprofit organization. This is what it looks like. This is the timeline of what a Title IX formal complaint, how it starts, and how it leads all the way to an appeal process. Hopefully it ends at an appeal. We don't see a Department of Education OCR complaint or, God forbid, a piece of litigation or a case filed against you or an Attorney General complaint investigating a specific issue. But this is sort of the process of what it goes through. We receive a report, whether it's from the individual who's reporting it themselves or a third party or someone who witnessed it or someone who was told that information. In initial assessment, a lot of you, as I'm seeing on our attendee list, fall under this portion where you are a deputy Title IX coordinator or a case manager where you're doing these initial assessments and determining whether a formal complaint and Title IX is being triggered, whether supportive measures are needed, whether we want to go through a different process altogether, and we'll talk about informal resolution here shortly. And then figuring out whether that is something that the individual wants to go forward with and filing a formal complaint, whether informal resolution applies, and then an investigation. This is the piece where probably the most amount of time is spent is that investigation portion where we're interviewing individuals, we're collecting evidence, we're trying to eventually give as many pieces to the puzzle, as much of that story as possible to ultimately allow the decision maker to render a decision based on the standard of evidence that your organization has put forward. And then an appeal process, making sure that there's that double check that your organization has to ensure that that adjudication process was done properly. Under the Title IX regulations, an institution gets notice of sexual harassment when they have actual knowledge of potential sexual harassment. The Title IX regulations are really clear about what that actually means, and that's when an institutional officer or someone with authority to take corrective action observes or receives a report of sexual harassment occurring in the institution's education programs and activities. A lot of times when we're doing in-person trainings or virtual trainings with our clients on their specific policies and procedures, I'll get a question from a random faculty member or employee that isn't involved in the Title IX process, and some of you may be those individuals who are attending today. And they always say, well, if I'm not sure, what should I do? Should I go on our website and try to sort of weigh the options and balance whether I think it's triggered? My response to that is always, if you're not sure, report. That's always my advice. That was really great and sage advice that someone gave me when I was a teacher, actually, when we had obviously different mandatory reporting requirements. And so I always give that advice here, where if you're not sure if you're someone with actual knowledge and you're not sure if sexual harassment applies and you're in one of these roles that maybe doesn't fit nice and neatly into your institution or your organization as it relates to sexual harassment, report it and let the folks who actually do those assessments, let them do their jobs and let them make those assessments themselves. Better to report it and it not to be something you should have reported, right? It never hurts to report it, than for it to be something that you should have reported and that you didn't. And some institutions have really robust processes for individuals who don't properly report. And so there could be consequences for not reporting when you're supposed to. I mentioned earlier the concept of a formal complaint. The regulations that were put forward in 2020 had this very specific process of what has to be within this complaint process, because before it was a little bit more murky since we didn't know exactly what should be reported. Some organizations would give that sort of who, what, why, where, and why conduct, and then other institutions would say, please come into my office and meet with me, you've been accused of something. And they wouldn't really dive into detail about what the investigation was entailing, what was actually going to take place. And so the regulations put a really prescribed process in place about what actually must go in a formal complaint. And so here's that requirement. For those of you who have this process in place, you know how to do this, but this is a great reminder. And I know for me, I have this slide and a couple of others sort of pinned on my bulletin board that I'm looking at right now when we're reviewing, because I serve in an investigator role occasionally. When I'm making sure that I'm doing an investigation, I'm sending out a formal complaint, you want to make sure that you have every single one of these boxes checked, so you don't want to ever leave anything out. Here's a breakdown of what the actual investigation framework looks like. Since this is the most robust portion of that really long timeline I talked about earlier, I wanted to break this down a little bit more succinctly. And maybe I'm biased because I serve in the role of an investigator, and so I wanted to dive a little bit deeper into this portion. So for me, this is sort of the meat and potatoes, as I think of it, as it relates to the Title IX sexual harassment process. Your formal complaint has gone out. You've notified the parties that you're moving forward as an institution, as an organization, and you begin interviewing. You interview the complainant, the respondent, and then any relevant witnesses. That doesn't just mean that you're interviewing the people who the respondent and the complainant identified. There's always that misconception where, well, I don't know if I should interview this person. They weren't identified by the complainant or respondent. That's your job as the investigator, is to independently determine if that person should be interviewed based on all the factors that you've heard, all the information you've heard. Just because someone isn't identified as a witness by one of the parties, if you've learned information about someone, I would go ahead and interview them. I would go ahead and try and collect evidence. And same thing with sort of the second phase of it, is collecting that evidence, the text messages, email exchanges, Snapchat, screenshots. I've even received before an Apple Watch tracker to demonstrate some of the material that happened during that time frame that was at issue. So any sort of information that may sway one way or the other, any sort of tangible physical evidence that could demonstrate whether someone is responsible or not. And then allowing the parties to respond to the report and to the evidence, making sure that they have an opportunity to properly respond, and making sure that you write up that report, and then that the ultimate fact finder, it could be a different person in some instances. For those of you who are higher education institutions, you have a hearing process that you all have to go through. For my K-12s out there, there are public school districts, you likely don't have a hearing process. You may have a separate adjudicator, but you probably don't have that hearing process in place. So I see that we only have about 3.5 minutes left on our presentation, so I'm going to jump ahead to some of the key concepts as it relates to informal resolution. Informal resolution is one of these areas that I think, for those of you who don't have Title IX applying to you, I would really encourage you to think about whether this is something that would really benefit from your organization implementing something like this, where it's an alternative to that that seemingly court or adjudicative or me versus them process that it can feel in an investigation. I do a lot of work in informal resolution, so again, this may be my own hat talking, but I really love this process, and I think there's a couple myths that I want to dispel. Is that just because you utilize informal resolution as an institution does not mean you have to utilize restorative justice. Restorative justice is a totally separate, related process. It's sort of a type of informal resolution, but if you're not interested in being trained on that process, you can absolutely utilize informal resolution, and it's definitely something that you should think about utilizing as an alternative to the process of investigation. And then our process ends with a appeal, and it's sort of a double check as it relates to that decision that was rendered by the either hearing panel, or for my K-12s out there, by the decision maker, and making sure that that process was done properly. This is how it concludes, and so I think it's pretty fitting that that's how our presentation will eventually conclude. Thank you so much for joining us. And for those of you who are interested, we do have a K-12 Legal Insights blog that we post about all sorts of content that could be helpful for your organization. We would encourage you to subscribe to that. We also, if you're interested in learning more about Title IX, we really did just a 101 training today. We're going to do a full day training compliant with the Title IX regulations that you can post on your organization's website. And we're doing that on January 18th. Mackenzie will be joining me, as well as our colleague John Borkowski from Indiana. So if you're interested in that, you can find the registration link in the resources folder. We really appreciate all of you taking the time today, and this has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen, and please share your recording tomorrow with individuals within your organization, and be sure to report with your certificate of attendance if that applies to you in your state. This concludes our webinar. Thank you.